Welcome everyone to Class 5 of Business Law at Columbia College. My name is Cassandra Jenneke and I will be your instructor for this course. Today we're going to be continuing our contracts journey. You'll recognize this screen here. We've gone over it a couple of times, but today what we're going to be talking about is element number 4, supported by consideration. So as a review, we've gone through the fact that a contract, in order to be valid and enforceable, must have an agreement, which is comprised of an offer and acceptance between two or more competent parties. And we talked about what competency means, right? That we, the people who are entering into the contract, understand, one, that they're entering into the contract, and two, what the general terms of that contract are. It doesn't require a very intrinsic or detailed knowledge of the terms, just what they generally are. And then that agreement must be based on the genuine assent of the parties. So no one's entering into the contract because they are under a mistaken impression, they've been deceived into entering into the contract, or that they have in some way been forced into the contract, right? And we talked about duress. So today what we're going to talk about is this concept known as consideration. Now, when we think about the word consideration, it doesn't have the same colloquial meaning in the law as it does in our normal everyday interactions. So consideration in contracts means that the promise or performance that the promisor demands as the price of the promise supports the belief and the intention of the parties to be bound by the contract. You may ask yourself or me, hey Cassandra, what in the does that mean? Well, there are other ways for us to define it, and this is how I want you to think about consideration. Very simply, consideration is what each of us gives up in the making of the agreement. So if I enter into an agreement for someone to come and mow my lawn every week, that person is giving up their time, their energy, and coming and doing the work in exchange for what I'm giving up, which is payment, right? So one way for you to think about and determine whether or not consideration exists in an agreement is to look for a bargained for exchange. So is something of value being given or promised in exchange for the performance of somebody else that they have promised to do within the contract? Now, value is given or promised in a variety of different forms, right? So you can give or promise to give money. You can give or promise to give performance of services. You can give property, so objects like a vehicle or a house, or you can forbear performance of a legal right. So for example, if I'm in a car accident and the other party has insurance, the insurance company could say, hey, listen, we'll pay for all of your damages, but you need to promise to not sue the wronged party, or the wrongful party, I should say. So you can agree to not utilize a legal right that you have, and that has value in it. Now, the reason why we talk about consideration is because you can make a promise to do something, but if you're not out anything in that promise, there's nothing to hold you accountable for not performing that contract or that promise. Versus, hey, if I am on the hook for the person mowing my lawn every week, if I don't want to pay that money anymore, boy howdy, do you think I'm going to cancel that contract first, right? And so when we both have some skin in the game, there is a larger inclination to, one, believe that a contract existed, right? Because courts are going to look at a situation and say to themselves, well, I mean, was it really a contract if one person wasn't losing anything? That doesn't sound like a bargain for exchange. And it shows that we have an intention to be bound by the contract because we're risking something by entering into the agreement. Another way for you to think about consideration and to look to see if a situation has consideration is to utilize the benefit-detriment approach, which means you look to see if someone is receiving a benefit or if someone is incurring a detriment. And if both sides are incurring both a benefit and a detriment, then you have consideration because they're both getting something in return for giving something. Now, this is a very large area of the law where I think a lot of our folks can get confused because, again, we don't talk about consideration in this way in our normal everyday life, but we do often promise to do things, right? So, for example, if I promise to not put my mother in a nursing home, let's say that's a promise I've made. The only thing that forces me to do that is love and affection and morality. Allow me to assure you, courts do not care about love, affection, or morality. They don't even care about it in family law. And the reality is that promises to do things where there's no benefit or detriment incurred on the other side are just promises. And promises are not enforceable in a court of law. Guilt is a completely different situation, but when we're talking about whether or not something you said to somebody is an enforceable contract, a promise to do something is not enforceable. So if any of you are regular donators to a charity of your choice, right? So the Humane Society, the ASPCA, God bless those Sarah McLachlan commercials, right? Anything like that. So those commercials will say something like, hey, you'll get a free t-shirt and a monthly update, and all for the low donative price of $19.95 a month, right? So what they want is for you to become a subscriber to their charity. They want you to send them money on a daily, weekly, monthly, yearly basis. Those charitable subscriptions are binding, but only to the extent that the person receiving the charity could reasonably rely on that promise for you to give money. So I would offer to you that the ASPCA monthly subscription, the ASPCA doesn't get to sue you for canceling your charitable subscription of $20 a month because it's not reasonable for them to rely on your promise to continue paying the ASPCA $20 a month. I'll tell you right now, it's not your $20 that's keeping the ASPCA afloat, right? But compare that to a charitable subscription or a promise to donate money to build, let's say, a building on a school campus, right? So I went to Boston University and they recently built a brand new international relations department building. They've done a huge expansion of the program, and there's a guy's name, though it eludes me at this time, there's a guy's name on that building. He paid and promised to pay for the creation of this department, pay for the building of that building. Now let's say he gave half of the money up front. So Boston University buys the land, they contract with a construction company, they pay out all this money, do all this planning, and then all of a sudden, midway through the project, the guy's like, oh, by the way, I'm not giving you the rest of that money that I promised I say I would. That would be a scenario where that promise to give charity would be a binding and enforceable agreement as a contract because it was reasonable for Boston University to rely on that promise. Because think about it. What are you getting out of donating to a charity? You may be getting some tax write-off. Okay, well that's a consequence of your act, but that's not something you're receiving in return for your action. You are literally giving a gift. And gifts, or promise to give gifts, are not enforceable contracts unless there is reasonable reliance on the promise. Now, you may ask yourself, well, like, what if I enter into like a really good deal for me? Like, it's so good, it's a steal, right? Like, I'm having to put out practically nothing and the other party's having to do everything and everything. Okay. The question that you're bringing up in your mind is adequacy of consideration. Is what I'm suffering as a detriment or getting as a benefit adequate in comparison to the other party, such that the court would look at our agreement and say, hey, you guys intended to be bound by this contract. Both parties are out something, both parties are getting something. That's an adequate bargain for exchange. Here's the deal. A peppercorn will do. Now, what do I mean by that? Well, hearken all the way back to the beginning of contracts law, right? So we're back in merry old England. The way that courts of equity and the way that courts of law, right, when they transferred here to the United States, the way that we thought about consideration is that, like, hey, listen, if you give anything, something, that's enough. So a single peppercorn is sufficient for a court to say there's consideration, okay? And this is because the courts don't want to make a off-the-hip, factual assessment of whether or not your consideration was adequate given the terms and conditions of the contract. Because again, hearken all the way back to freedom of contract, the reality is that courts want to enforce contracts. If you entered into something that looks like a contract, walks like a contract, sounded like a contract, there is a really strong chance that absent it being for an illegal purpose, they are going to force you to stay in that contract and to figure it out and to perform, because we love freedom of contract. So even if you enter into a really bad deal and you go and look back and you're like, oh God, that was awful, absent it being so grossly inadequate as to shock the conscience of the court, the consideration was adequate. Okay? So keep that in mind when you're wheeling and dealing as a business owner, as an employer. Absent gross inadequacy, what you give, so long as it's something, will be enough to find consideration. We've spoken about forbearance already. The issue really for us becomes, well, what happens when you entered into what you thought was a valid and enforceable contract, but come to find out it's not because of a lack of consideration. It looked like a contract, sounded like a contract, but when you started performing and you figured it out, the other party incurred no detriment. What we have there is an illusory promise, right? So it was the illusion of a contract, but it was actually a promise because one party was not suffering a detriment, okay? So illusory promise is defined as a promise that, in fact, does not impose any obligation. So it may sound like it does, but in fact, as it's happening, it doesn't. So when we talked about, at the very beginning, definitions, right? We talked about bilateral contracts. And bilateral contracts rely on the mutuality of obligation, right? Both parties have to perform in order for the contract to be triggered. If one of those parties makes an illusory promise, then that contract fails for lack of consideration. So for example, let's say I'm not a very good lawyer, and I just get out of law school, and I'm not a really attractive employment candidate, but my mom is really rich and owns a company where she could give lots of legal business to a company that hired me, right? A firm. So I go in for a interview, and they actually really like me, and they hire me. And I'm so excited that I don't tell my mom. I just go on a vacation. I just head out of town. My mom knowing that I'm not the brightest bulb in the pack, is like, oh God, okay, so she had her interview. I'm going to call that firm and tell them, hey, listen, if you give my daughter a job, I'll give you all of my legal business, which, you know, because again, real bougie, is going to amount to over $1 million. So the firm is sitting back and they're like, oh man, let's think about that. Okay, so we already agreed to hire her because she's not that bad. So we're going to agree to hire her and get $1 million in legal business. Easy, right? Super great deal for the law firm. But we go backwards, or we go forwards in the actual act. My mom is suffering a lot of detriment for no additional benefit, right? I was already going to be hired. So when my mom looks at this situation, she's like, well, they're not suffering a detriment because they were going to hire her anyway. So what happens is that this is an illusory promise. The contract that looks like a contract, sounds like a contract, but isn't a contract, fails because the law firm that hired me isn't suffering any detriment because they had already decided to hire me. If they were like, oh, we wouldn't touch her with a 10-foot pole, but we're going to get $1 million in money, we'll hire her and stick her in an office where no one can find her, that's a detriment, right? But in fact, there was no obligation for the law firm to perform because they had already agreed to perform with me when they offered me the job. Now, some other types of provisions that may look like illusory promises, make a contract look like an illusory promise, but actually don't because we want these types of provisions to be in contracts, are specifically cancellation provisions. So oftentimes you will enter into a contract where you're able to cancel that contract. Sometimes there are terms and requirements prior to cancellation, but otherwise cancellation provisions are allowed because, again, we want people to be free to enter into contracts, and some folks may not enter into contracts unless they have a way to get out of them. Another one that may look illusory but isn't are things called conditional promises. So I know you're saying to yourself, Cassandra, you're not supposed to use the P word, right? No promises here because we want a valid and enforceable contract. I hear you, but here's the deal. Conditional promises are contracts that are not triggered, well, that performance is not triggered for until a specified condition occurs, right? So it may be something like, if this happens, then we'll do this, okay? Or it may be, if I get the funding, then I'll hire you, okay? So it's kind of the conditional promises are if-then contracts that allow for there to be a triggering event that will bind people into a valid and enforceable contract. So, what can and can't be consideration? Well, we talked about the fact, right, that love and affection and morality, those aren't monetized things that can count as consideration, right? I want you to think about when we're talking about if consideration exists, is there a monetary value that you can assign to the consideration? So be it a service, be it an object, be it a cash value, there has to be some sort of ability to monetize its value, okay? Some things that are not consideration. Pre-existing legal obligations. What does that mean? Okay, that basically is doing or promising to do something that you are already obligated to do. That is a pre-existing legal obligation. Offering to keep doing that is not consideration. It's in fact an illusory promise. And I reference you back to the example that I just gave you about my mom, the law firm, and my hiring, right? The law firm was already obligated to hire me because they'd already made me an offer that I had accepted. There was a pre-existing legal obligation. So they can't say, oh yeah, we'll go ahead and hire her, because that legal obligation to hire me already existed. They are not giving anything, therefore it's an illusory promise. Now, There are certain situations where the courts and the law recognize that sometimes stuff can get in the way of performing a pre-existing legal obligation. So this is particularly true where we're talking about construction contracts. We call it a good faith adjustment because sometimes what will happen is that there will be a supply that you're contracted to provide or to use on a job that all of a sudden becomes unavailable, hard to find, or the price goes up. That's not something that a contractor can control oftentimes, nor is it something that they can easily predict. And so the courts recognize that, hey, sometimes in a construction situation, the contractor may have to come to you and be like, hey, listen, there were some really extraordinary circumstances, unforeseen difficulties in getting this job done. I'm going to do it, but you have to pay more money in order for me to do it. I know I'm already obligated under our contract, but I can't perform the way that you want me to and the way that we agreed to unless you give me more money. Okay? Now, can you also choose to utilize inferior supplies, things of that nature? Absolutely. Absolutely. But if you want to keep the really expensive teak wood that half of the Brazilian rainforest burned down last year, teak's going to cost you a little bit more. Okay? So, another area would be contract for sales of goods. Now, the UCC governs pretty exclusively contracts for the sales of goods. So long as modifications to a sale of goods contract is in good faith, that can be binding without there being additional consideration. So, for example, if prices go up, if there's a transportation issue, promising to perform and to continue performing, you don't need additional consideration in order to modify those terms and conditions of the contract. Some other ways that pre-existing legal obligations can come up specific to consideration. So one area where my students are always like, oh my God, I want to try this, but I have to remind them of the good faith portion, is the second bullet point on the screen. And that's specifically past payment checks. So if you have a credit card and you claim that there is a fraudulent payment on that credit card, right? Not payment, but charge. Someone stole the number, what have you, bought something in Timbuktu, I don't know. And you tell your credit card company and they don't do anything about it. They're like, oh, sorry, we think you were in Timbuktu. We're not going to do anything about it. You have to pay. What you can do is you can write a check for the full amount of what's owed on the credit card minus that fraudulent or allegedly fraudulent charge and write in the checkbox, paid in full. And if they cash it, then your entire debt is discharged. Amazing, right? Like, who doesn't want to send in a $1 check for a $100 charge and put paid in full and just wipe your hands of it, right? And again, you have to have a good faith dispute about what is owed. Okay. Also, creditors can agree to accept full or partial payment for full settlement of your debt. So I don't know if any of you are up at 2 a.m. Sometimes I am. Team no sleep all day. Sometimes you'll see those debt consolidation commercials, right? Basically what those folks do for you is they call all of your creditors and they're like, hey, listen, we're going to put her on a payment plan. Out of the $5,000 she owes you, Chase Bank, what if I promise she's going to pay you $3,000 over a 2-year period? Can you just forgive the other $2,000? So your creditors can come to a composition of themselves and agree for partial settlement, partial payment for full settlement of your debt. And that's what those debt consolidation folks end up doing. Past consideration is not consideration. So if you've already given something up, suffered a detriment in the past, kind of the same thing as pre-existing legal obligation. But if it's an object, right? Like if I'm already promised to sell my car to somebody, I can't then be like, oh, let me take a loan out on that car, right? You can't do that. Moral obligations, as I've mentioned, my mother going into the home or not. Promises that you make based on a moral obligation are not enforceable as valid contracts, legal contracts. And then, as we've talked about, some exceptions to consideration, the charitable subscriptions, which we've already talked about, the Uniform Commercial Code, so for those contracts for sales of goods. And then we talk about this concept of promissory estoppel. So typically, if you enter into a contract and there's something wrong with it, the court's going to hold that against you, right? Like you signed it, you read it, that's on you. But if a contract is not valid and enforceable because it lacks consideration, right? That illusory promise gig. If the other party reasonably relies on the contract existing, okay, and they suffer a detriment, then the other party will be prevented from claiming that the promise is unenforceable. So, for example, in the scenario that I gave you earlier about my mom, the law firm, and my hiring, let's say, for example, that my mother relies on this contract. So what does she do? She shifts all of her legal business to this new firm. And then that firm violates their attorney-client privilege and screws up a really important case, and my mother suffers a huge legal loss. Okay, so she has suffered a detriment as a result of this contract existing. And then she sues the law firm that I work for bad lawyering, right? The law firm doesn't get to come back and say, oh, listen, you can't sue us based on that because it actually wasn't a real contract. It was just an illusory promise. And so it's unenforceable, and so we never had a contract, so you don't get to rely on that. No. So, if there's reliance, that's reasonable, and another party suffers a detriment, then the other party to that contract or illusory promise doesn't get to come back and say, oh, no, you can't enforce it. It's not a contract. So that is our lesson on consideration. If you guys have any questions, bring it up in our labs next week. Otherwise, I will see you next time.